So what's the big difference between B2B telemarketing law and B2C? Business-to-business telemarketing is great, but it's subject to a lot of the same rules. So for example, the cell phone rule, that protects all cell phones, business cell phones and consumer cell phones. And that rule is that you're not allowed to auto dial or auto text any cell phone for marketing without prior express written consent. So same rule, B2B and B2C. What's different? The National Consumer Do Not Call List, thankfully, was not designed to protect business numbers. So, in theory, if you were 100% certain that none of the lines you were calling were consumer or private residential lines, they were all genuinely, exclusively business lines, owned by a business, paid for by a business, used only for business purposes, then even if that business owner put the line on the Consumer Do Not Call List, it's not technically a violation to call it. However, we strongly encourage our B2B clients to scrub consumer D&C anyway, state and federal, because of some growing risks. One, the risk related to mixed use or dual purpose lines that might be owned by a business but used primarily or at least in part for private, personal, family purposes. Or the reverse, where Eric Allen, the person, is the individual owner of the line, the subscriber, but I use it as a business line. It's on business cards, it might be on a business website, business letterhead, LinkedIn profile, etc. So because of the risk related to calling a mixed use or dual purpose line, where you might think it's a business line and so you don't have to scrub D&C, but you call it and the owner feels like it's mostly their private personal line and they bring a lawsuit, you don't want to have that fight. This is especially important given in late 2023, the Ninth Circuit Court of Appeals ruled for the first time that if a number happens to be registered on the consumer D&C list, courts can basically assume it's a private number until the defendant, the caller, proves otherwise, until the defendant affirmatively demonstrates that the line is a private or residential line and not a business line. So it puts kind of a rebuttable presumption in place that's tough for defendants. What about state stuff? The good news is B2B calls are exempt in many, many states. Not every state, but a lot of states would exempt B2B only callers from having the local license and bond, from certain disclosure, curfew, and other consent requirements. But some states still require B2B callers to license and register and follow their local rules. What about business landlines? There's a lot of misinformation out there about that. Business landlines technically have no significant protection under the federal telemarketing rules. I'm allowed to use an auto dialer to deliver a pre-recorded message to a business landline. Could that change in the near future? Yeah, there's a number of bills and regulatory efforts to protect those lines. So in short, B2B is exempt from some but not all of the rules. Be careful for cell phones. Continue to scrub consumer D&C. Do your state analysis and get the licenses and follow local rules that apply, and have a successful B2B campaign.